So the ethical standards within the legal profession, what we're going to be looking at is the legal code, right? We're going to be looking at what the focus of the defense is supposed to do, the defense counsel, what's the focus of the prosecution is supposed to do, right? And generally things that can get you sanctions, whether it be suspensions, disbarring, fines, stuff like that, right? So we're looking at the code here now, lawyer to lawyer, right? So within lawyer to lawyer relationships, you have a civility and courtesy. Lawyers should not treat fellow lawyers with should not well should rather lawyers should treat fellow lawyers with respect, courtesy, and professionalism regarding differences in their opinion and partiality. Right? There must be there must be some honesty and candor. Right? So lawyers should communicate truthfully and honestly with each other. Right? We also have cooperation and collaboration. Lawyers should cooperate with opposing counsel and engage in good faith efforts to resolve disputes and streamline legal proceedings. There's also some confidentiality. Lawyers should respect the confidentiality of information shared by opposing counsel and refrain from disclosing privileged or confidential communications without consent. And we also have fairness and zeal. While advocating for their clients' interests vigorously, lawyers should adhere to principles of fairness and avoid engaging in unethical or overly aggressive conduct towards opposing counsel. So these are the things that lawyer to lawyer relationships speak to, right? As it relates to lawyer to client relationships, now we know that we have a duty of loyalty, right? The lawyers owe the duty of loyalty to their clients, prioritizing their clients over anyone else's, avoiding any types of conflicts of interest. We also have competence and diligence. The lawyers should provide competent and diligent representation to their counsel, right? Well, to their clients, applying their knowledge and skills effectively to advance their clients' objectives. Communication transparency as well, so the lawyer must communicate regularly and effectively to their client, keeping them informed about status of the case, significant developments, and any available options. We also have informed consent. Lawyers should obtain informed consent from their clients before taking significant actions or making decisions that may affect the client's interests. We also have fee transparency and reasonableness. Lawyers should provide clear and transparent fee agreements to their clients, ensuring that fees are reasonable and proportional to the services provided. And we have confidentiality. Generally, lawyers must maintain confidentiality and client information of client information and communication. So attorney-client privilege, basically, right? Some cases that look at that, the breach of these issues, right? This case would have been Ford v. the Law Society, 1987, right? And so that zero is not supposed to be there. The zero should be a bracket, right? And Niles, right? 1987 as well, right? So those two cases are important there as it relates to understanding lawyer-client relationships, right? So you guys could take down those cases and read those cases. They're important as it relates to this, alright? Okay. So basically what's happening here is that in Ford, right, v the Law Society, right, we had some transactions, right? Some money transaction. So he basically deposited some money from a business account and did not um, take it from the client's account itself, right? So he basically lended into some amount of dishonor, right, with the bank, right? And this okay, so basically what was happening was a lawyer took money from the wrong account, right? So he took the money from the business account instead of the client's account, right? And that wasn't clear. It wasn't transparent between the client and the lawyer specifically, right? And within Niles, right, what we have is the purchasing of a piece of land, and the attorney never completed the transaction and failed to turn over the funds, and that when the funds when demanded rather, right? So what happened was a disciplinary committee was convened and an investigation was put out, right? So they found that professional misconduct was taking place, and the committee referred the matter to the High Court. Right, so I think you guys should read up on for the Law Society and Renals, right, for more understanding of those cases, right? Loyal to court relationships, so there must be candor and honesty. So lawyers have a duty to be candid and honest, right, with the court, presenting accurate information and disclosing relevant facts and legal authority. Respect for judicial process, though, so the lawyers should respect the authority and independence of the judiciary, complying with court rules, orders, and procedures. Professionalism and decorum as well. So there must be some amount of professionalism and decorum within the court proceedings, adhering to standards of civility, courtesy, and the respect of the judiciary. So you have to respect the courts. Preparation and diligence. So lawyers should be thoroughly prepared for court appearances, hearings, and trials, so not as to waste the time of the court. That is important, right? Adherence to legal ethics as well. Lawyers must comply with legal ethics rules and standards governing their conduct in court, including rules of professional responsibility, ethics codes, and court rules. So those are generally from the codes. So lawyer to lawyer, lawyer to client relationships, and lawyer to court relationships. So the defense and the prosecution, no. Defense counsel. We see here that defense counsel, right, has some rules here. They must have a duty to the defendant, right? We must have the presumption of innocence. The defense counsel upholds the principle of the presumption of innocence. They're innocent until proven guilty, right? To prevent any type of unfairly prejudiced attempts or accusations, right? They must have zealous representation, so you must represent the counsel, right, to the best of your ability, right? So challenging the prosecution's case, cross-examining the witnesses, and presenting evidence and arguments to favor the client's innocence, right? You must be able to zealously represent the client. Confidentiality, no. We know that defense counsel maintains confidentiality with the client. So we have attorney-client privilege there. We have the burden of proof. The defense counsel reminds the court of the prosecution's burden of proof beyond a reasonable doubt, right? Emphasizing the presumption of innocence and necessity of proving guilt, right? We also have ethical boundaries as well. Defense counsel adheres to ethical boundaries, refraining from presenting false evidence misleading the court or engaging in tactics that undermine the integrity of the legal process. Right? So these are generally the things that the defense counsel must uphold. For the prosecution, no. The prosecution are the people who would then generally seek justice on the behalf of the state. Right? So they must prosecute within public interest. Right? They must hold individuals accountable for criminal conduct, right? So they must adhere to the ethical standards and avoiding conduct that may undermine the public confidence in the criminal justice system. They must react with professionalism and integrity, right? Prosecutors are the ones that bear the burden of proof, so they must show beyond reasonable doubt that the defendant had committed the crime. That is one thing that they must do, right? They bear the burden of proof. They have the disclosure of obligations as well. Prosecutors have an obligation to disclose exculpatory evidence and information that may be favorable to the defense, right? So even if the evidence that they find through investigation is favorable to the defense, they must provide that as well, right? Fairness and impartiality is important as well. So fairness and impartiality in the administration of justice, upholding the rights of the accused while vigorously pursuing accountability for criminal offenses. So not because you're prosecuting the defense means that the defense doesn't have rights. You must still uphold the rights of the defense, right, or the defendant, while you try to secure the criminal charges, right? Sanctions for breaches of these codes now, right? We have striking off or disbarment, right? So this usually speaks to the fact that the license to practice law, right, is revoked. We can see this in Othniel Sylvester versus Disciplinary Tribunal of 2008. That is a case there for disbarment, right? So any huge or repeated violations can result in disbarment, right? We have suspensions as well. It is less severe, right? So it's usually imposed for less severe ethical violations or misconduct that doesn't warrant disbarment. So, right? So it's generally used, right, in conditions for reinstatement, such as completing ethics courses are undergoing rehabilitation. So you need to undergo these things before you can regain your practicing with the legal license, right? So if you're suspended, you need to go through some processes in order to get back. All right. You have a fine as well. So for petty misconduct, monetary penalty for ethical breaches or misconduct, right? So the amount may vary depending on what's happened, right? What happened. So lawyer's financial. So what we're looking at now is determined by the lawyer's financial means and any aggravating or mitigating circumstances. So fines are both punitive and deterrent purposes, right? They're used for both of those purposes, discouraging unethical behavior and compensating for any harm or damage caused. We also have compensation generally. So in cases where the lawyer's misconduct results in harm or financial loss to the client or third party, compensation must be offered as a sanction. So the lawyer must be required to reimburse the affected party for damages, legal fees, or any other losses resulting from the misconduct, right? So one of the integral cases here would have been Regray 1892, right? A case on compensation within the scope of our syllabus. All right. So that is it. Those are the different ways, and that is it for our review of module 1.